Yes, hi Ajna, can you hear me? Hi, can you hear me? Yes, that's good. So, without further delays, let us start. And if ever you want to ask questions, not just to interact with me, you are most welcome. No need to just chat in the chat box, because it is essential that we connect and speak whenever necessary. Just this increases the interaction during the class. So if you want to sometimes join the call and ask some questions orally, you are most welcome. And let me share with you my screen. Here you are. Please let me know if you seeing my screen and questions that I sent last week on sources of law. Sorry. Okay, can you see my screen? Yeah, that's perfect. Okay, first of all, before we start, do you have any questions on what we did last week? Right, that's good, that's perfect. So let's see the first questions. Actually, these are objectives questions, all right? We have, as I mentioned earlier, our paper is divided into two sections. One is the objective questions, and the other is the multitask questions. So what we are practicing is objective questions. The first question is, which of the following is a statement by a judge which is the basis of their decision and what becomes binding in future judges? So what do you think is the answer? Obiter dicta, per incuriam, or C, ratio decidendi? A, B, or C? C, that's good. Yes, it is ratio decidendi. Which of the following types of court decisions occurs when a court higher in the hierarchy overturns the verdict of a lower court in the same case? Overturns the verdict of a court of a lower court in the same case, all right? So what do you think? Reversing, overruling, or distinguishing? No. This is actually reversing. Reversing decision is made when a case is appealed. And overrule decision is when the case overturns the decision of a lower case in a different case. Here it is in the same case. Overruling, it is in a different case. It does not change the ruling of the case, but it takes it into consideration so that further cases are not taken the same decision of the previous course, court's decision. But reversing is overturning of a decision of a same case. The higher court or the hierarchy, they overturns the lower court's decision in the same case. The same case is like the key phrase here, which means over reversing. Which means reversing. Overruling is again overturning the decision, but it is in a different case. All right. Okay, which of the following in relation to legislation is correct? Legislation may modify or replace existing statute. Legislation may not overrule or modify existing case law. Legislation may prevent a subsequent parliament from changing the law. So what do you think? Yeah, all right, that's good. Legislation may modify and replace existing statutes. This is the parliamentary sovereignty, the power that legislation has. It may replace an existing statute. Which of the following types of legislation affects specific individuals or group? Specific individuals or group. Enabling, public, or private. A, B, or C. All right, that's good. C, of course. Public is for the whole nation, and private is for specific individuals or group. Which rule of statutory interpretation says that words of a statute should be given in their plain ordinary meaning unless they give a manifest absurdity, inconsistency with the rest of the statute? Golden rule, mischief rule, or contextual rule? So what do you think is the decision, the answer, A, B, or C? Right, that's good, the golden rule. The contextual rule is based on the context. The mischief rule is that the judge should consider what mischief the act was enacted to prevent. But the golden rule, a word may have several signification. They select this one which doesn't give absurdity or inconsistent meaning. Which of the following is an intrinsic aid to statutory interpretation? A, B, or C? Hansard, the long title of the ACCA Law Commission report. Yeah, that's good. B, the long title of the ACCA, the Hansard and Law Commission or extrinsic reports. And question 7, which of the following is a final appeal court for human rights for persons living in UK? The Supreme Court, the European Court of, B, of course, the European Court of Human Rights. That's good. I've seen that you have been revising your notes and you're very good on the right track. And if you continue in the same way, you are going to get very high marks. The decision of which of the following courts is binding of the Court of Appeal? The Crown Court, the County Court, the Crown Court, High Court, or the Court of Appeal? A, B, C, or D? No. The Court of Appeal itself. The only court that binds the Court of Appeal or the Supreme Court and the European Court of Justice and anything else. What courts that bind to the Court of Appeal is only the Supreme Court and the European Court of Justice and itself. Here's the answer: is there is no European Court of Justice or Supreme Court, then it is itself. Which of the following statement concerning the principle of binding precedent is not correct? Mistakes by judges are eliminated. General legal principles are established. The law is based on actual rather than theoretical cases. The law is flexible and can develop from changing circumstances. So, what do you think about the binding principle is not correct? A, B, C, D. You say A. Yeah, mistakes from judges are eliminated. Very good answer. Means that mistakes by judges can never be eliminated. There are options, correct statements concerning binding precedent. So, but they are never eliminated. Okay. So we have some further questions on it. I will be sending the the answer, but I see that you're on the right track. Let's see this one. Which of the following is an extrinsic aid to statutory interpretation? Extrinsic. Tell me, what is the answer? You say A, Hansard? Yeah, it is the right answer. Hansard is like the extrinsic aid for interpretation. The long title, the preamble of the side notes are all intrinsic aids. Okay, so I see that you have been revising your notes, and I will be sending you the answers for all these later and questions for next week. And also, I sent you the lecture note. I thought that the coordinator has been sending you the lecture note, which is not the case, but I will be sending you all each and every week. And now, let us move forward to our next topic. Okay. So we are going to start part B, the law of obligations. Let us first of all go back on our syllabus. Okay, so we did the first 2 weeks on introduction, the part A, the essential elements of the legal system. We studied English legal system and sources of law, and now we are going to on the part B of the syllabus and the chapter 1, which is formation of contract agreement. And these topics are quite interesting. It has some minimal technical terms in contrast with these the two first session, which we had some like terms, some terms such as like ratio decidendi, obiter dicta, or some technical terms, binding precedent. But this one, they are quite like it has some rules, some regulations for each chapter, but they are quite less they are less technical terms in contrast with the first chapter. Okay, so without further delay, let us start our second session our third session, sorry, which is the law of obligations, and the chapter 1 of the part B of the syllabus, which is formation of contract agreement. All right, just a general explanation. To have an agreement to occur, we have two parties, party A, for example, and party B. Okay, for example, party A makes an offerer. Offerer is the one who makes the offer. All right. So, for example, party A makes the offer, send the offer. For the agreement to occur, first of all, there need to be acceptance from the other party. All right. So there need to be acceptance from the offeree. For an agreement to occur, first of all, again, we need to have the offer from the offerer and the acceptance from the offeree. And then this is how agreements occurs. This is how they are now. When there is an acceptance of the offer, there is no way of going back. All right, there are no further negotiations. The offer has been submitted to the party B. The party gives his consentment to the offer. The agreement occurs, and there is the point of no going back. The terms of conditions has been agreed, and they are not going to do some further negotiations. So this is how agreement occur. So in this chapter, we will be studying offer, the acceptance, what are not offers, and how acceptance are generally carried out. So generally, the chapter overview, we have first of all the formation of a contract, the first part, the identification of a contract, the essential element, validity factors, general issues surrounding a contract, the types of contract like deeds, all right, contracts that must be in writing, or contracts that must be evidence in writing. And then for third part, we go through offer and acceptance, that is agreement. So the overall objective of this chapter is to analyze the nature of a simple contract. Okay, the meaning of an offer, distinguish it from invitation to threat. We will go through this later. What is invitation to threat? Explain the termination of an offer when an offer terminates. All right. For example, if there is silence from one party, if silence doesn't mean acceptance. All right, and it has some period of time in which it can be accepted. And explain the meaning and consequence of acceptance. All right, the meaning of acceptance, which is the point of no return. Consent has been given to go forward on the offer, and this is again the point of no return. And the meaning and the consequence of the acceptance. And when you have sent your acceptance, you are bound to the terms and conditions of the contract. First of all, definition of contract. A contract may be defined as an agreement which legally binds the parties. Okay? When I enter a contract with someone, I am legally bind to him under the terms of conditions of the contract. The underlying theory is that a contract is the outcome of consenting minds. Consenting minds. This is a very important point. For contract to occur, there needs to be both parties has agreed to the terms. They can't be like undue influencers. They can't be that they are signing this contract under pressure. These are not the way that contract should be conducted. There need to be consenting mind. All right? There must be a willingness between the parties to enter into a contract. So this is what about a contract, an agreement which regards both parties, and they must agree to join to go through to legally bind under the terms and conditions of the contract. Okay, the essential elements of a contract. The courts will usually look for evidence for three essential parts in any contract. When the courts, for example, if tomorrow a dispute occurs in a contract, this goes to the courts. The courts usually look for three elements in the contract. Agreement, to see whether truly an agreement has been taken place between the parties. And for the agreement occur, they need to have an offer and acceptance. Okay? First of all, the elements that the courts are going to see tomorrow if there is a legal case occur due to a contract, due to an agreement between two parties, but the court will see first of all whether has there been really an agreement between them. And how will they see this? They will see whether there exists an offer that has been made, an acceptance that has been made. Consideration, there must be a bargain to which the obligation assumed by one party supported by consideration given to the party. Consideration is above all what is the value, what is being exchanged for providing the service under the contract. This is all about consideration. All right? So as it says, a bargain in the obligations assumed by one party. It is supported by consideration. Consideration means payment. Okay? intention to create legal relation. Yes, this is very important. The parties, when entering into agreement, they must have the intention to create a legal relation, because when they are going to enter the contract, they are going to be legally bound under the contract. Each party agrees that they will be legally bound by the agreement. So this is the three essential elements that the courts will see if tomorrow there is a case between two parties, disputes between two parties, under, like, for example, a contract. And just to remind you, a contract between two parties, this falls under civil cases and or private laws, all right? Because this is between private individuals. Okay, so first of all, the contract agreement which legally binds the parties. And secondly, the essential elements of contract. First of all, there need to be an agreement which is offer and acceptance between the parties. Secondly, so the essential elements, these are the three essential elements that the courts are going to look at if tomorrow there is a case at the between they dispute a case between two parties which let's say has entered into a contract. Secondly, consideration, obligation under the contract between the parties. And thirdly, intention to create legal relation. The parties know and agree that they are going to be legally bound under the agreement. So this is the first, the three elements of the contract. Now let's move forward. Okay, some contracts must be made in a particular form, such as writing. Okay, yes, some contracts are such as deeds, land. You are purchasing a land with someone. This must be made in writing, or you are going to rent a floor in a building at Eben. Of course, there will be a lease agreement. For most contracts, however, there is no special requirement. All right, and an oral agreement is binding as law as a written. Even if a contract has been made oral, there has been oral, which means not in writing, in discussion. All right, this is as binding in law as a written agreement. All right, even oral agreement is binding in law as written agreement. Okay, so it is not always necessary that the contract is made in writing. Some contract of specific nature has to be made in writing, but even oral agreement is binding, same as written agreement. Validity factors. What is validity factors? Right, these are the factors which makes a contract validated. It's as simple as that. even if the essential elements can be shown, the essential elements of the free evidence that the court will be shown, a contract may not necessarily be valid and may be partially valid. So even if this has been proven, the contract may not necessarily be valid or may even be invalid, partially valid, sorry. The validity of a contract can be affected in the following factors. These factors, which we are going to discuss below, they affect the validity of the contract. First of all, capacity. All right. Some persons have restricted capacity to enter into contracts, such as minors under 18 of age. All right. And those with reduced mental capacity and those intoxicated while making the contract, of course. Okay. Even if we had a contract which we see an agreement, a consideration, and intention to create legal relations, but we see that the person that signed the contract, that provided his consent to enter the contract, he has a reduced mental capacity, then this affects the validity of the contract. All right. Even if the above three essential elements have been proven, but still the factors below, they are going to affect the validity of the contract. For example, capacity, here we see minors, someone with under the 18 of age, someone with reduced mental capacity, or someone who has been intoxicated while making the contract. So these factors, like for example, will affect the contract. Form, some contract must be made in a particular form. All right. For example, here we can say a contract of generic nature. All right. For example, an electricity company, which making you entering the contract as a public. So he will not make a contract specific for you. The terms and conditions are always general for the public. So the contract is of a standard nature. It is a form which you have to fill and you sign it. That's it. And when you sign the form, you are legally bound under the contract, under the terms of the conditions, under the form. The content. Content of the contract can be express or implied. Express terms means that are spoken or written. These are terms that has been mentioned in the contract. All right. However, implied terms or implied terms are not necessarily written under the contract, but they are legally bound to these terms. All right. The implied are what are deemed to be understood and need not interpretation. And an example for implied terms is that even if you want to enter the contract and you have the express terms, the implied terms is the law which governs the section under which you are entering the contract. And these are the laws, the general laws that you as a citizen needs to be aware of. For example, you enter in an employment contract, you are legally bound with the company. Okay, you have the companies the companies will mention its terms and conditions. Okay, and also, but however, you are also for example, need to follow the employment rights, the employment law as well. Okay. Again, I say it. For example, if you enter into employment contract, into an employment contract with a prospective employer, you are first of all there will be the expressed terms, which are the terms under the contract of employment, the policies, generally the policies of the organization, okay, which you have to follow, which you have to bind under it, but you have also the implied terms, the terms which govern employment laws. All right. And now, in general, parties can enter into a contract on whatever the terms they choose. Some terms of the parties do not express, may be implied. and some terms which the parties do express or even overridden by statutory rules. For example, again, in a employment contract, may have been some express terms, but however, under the statute, there are some protections for the employees on this, and therefore these express terms overridden by statutory rules. Genuine consent. A mistake or misrepresentation made by one party may affect the validity of a contract. Parties may be induced to enter into a contract by undue influence or others. These are genuine consent. Genuine consent means that the party, when entering the contract, they has agreed to enter the contract. They understand all the rules and regulations under the contract, and they has not signed the contract under undue influence. Undue influence, such as, for example, pressure, right? Means that there's something other than the free will. Okay, so like they need to enter the contract under their free will. They need to understand the terms and conditions, and they need to accept to it. There need to be no undue influence, pressure from any party to make them entering the contract. So mistake misrepresentation, again, these also affect the validity of a contract. Okay, legality. The court will not enforce a contract which deemed to be illegal or contrary to the public policy. All right. Again, if a contract has been made whereby a party is is going against the law and undermining the other party's rights as being a member of a country, of a legal country. So if this is the case, the terms and conditions which deems to be illegal to the country or contrary to the public policy, the courts will not enforce such a contract. Again, so like for example, a contract which, like for example, affect the rights of someone. So these types of contract, the courts will not enforce such contracts. A contract which doesn't satisfy the relevant tests may be void, voidable, or enforceable. Okay, we will see this in later on. So first of all, let's discuss now on the notes on validity factors. Even if the essential elements can be shown, a contract can be invalid or partially valid. And be affected by the below factors. Capacity, people, example, people with restricted capacity minus reduced mental health, or someone intoxicated when the contract was being made. Capacity, the form, all right, form or contract or generic nature. A content can be expressed or written. Or implied. Express means express or those that has been written. Or oral terms in a contract. Implied is like, for example, you have to follow by statute or nature of the contract, or custom or usage. And this one or usage, all right? And implied terms are to follow even if not express. For example, when you're entering the contract, employment contract with a third party, you are, of course, you have the express terms like the policies of the company, and the implied terms, the rules and regulations under the protection of employment laws. Okay. And one thing which I need to mention here, some terms not expressed may be implied, like for example the laws, and some expressed may be overridden by statute. For example, if an express terms is like, for example, is affecting the rights of someone, then this can be overridden by statute. Genuine consent, sorry. Mistakes or misrepresentation affect misrepresentations or even undue influence affects the validity of a contract. Legality, which is a contract which is itself illegal. Example, a contract which is itself illegal. And so a contract which failing the above tests, capacity, form, content, etc., this renders the contract void, voidable, or unforceable. Okay. So now, a void contract. A void contract is not a contract at all. Okay. These the parties are not bound to it, and they transfer property under it. if they sometimes recover their goods even from a third party. If there is no contract at all, they can recover their goods and so on. Avoidable contract. Avoidable contract is a contract which one party may set aside. Okay. Property transferable before avoidance is usually irrevocable, irrecoverable from a third party. For example, avoidable contract is a contract failure for disclosing items as required by law. Misrepresentation, all these things render a contract voidable. Okay, and also a contract which is voidable if the agreement is auctionable but the circumstances surrounding the agreement are questioned by nature. Okay, these are voidable contract. There are some misrepresentations of informations which can make it voidable. When it is voidable, which means that, for example, some terms and conditions are misrepresented, any parties in the contract may set it aside, meaning that they can make the contract void. There are some information which is missing on the contract, they can, like for example, decide not to go on with the contract. An unenforceable contract. An unenforceable contract is a valid contract, and property transferred under it cannot be recovered from other party of the contract. Okay, an enforceable contract, it is a valid contract first of all. Okay, but if one party refuses to perform or complete their part of the performance of the contract, the other party cannot compel them to do so. It is first of all a valid contract, an enforceable contract, and the property transferred under it cannot be recovered. This is the first point. But however, if either party does not want to complete their part in the performance of the contract, the other party cannot compel them to do so. This is when, again, when there is misrepresentation or lack of information, or there is a lack of evidence as well. A contract is usually unenforceable when the required evidence of its terms, for example, the written evidence of a contract relating to the land, is not available. Okay. This is generally when the evidence of the contract is not available. So, just to summarize it here, a void contract. Void contract. So again, a void contract is what? A contract which is not a contract at all. And therefore, if a contract is not a contract at all, the parties are not bound by it. So this is a void contract. So here, the contract itself, it is void. So the parties under it are not legally binding under the contract. Excuse me. Voidable contract. A contract where one party can set aside, which means make and therefore make it void due to misrepresentation or, for example, misrepresentation or lack of information disclosed. So failure for disclosing items as required by law or misrepresentation of information render a contract voidable. So one party may set aside. May set aside, which means they decide not to go on with the contract. Which means they decide not to go on the contract and meeting its terms and conditions. Okay. Again, what makes it voidable. Example, another situation which makes the contract voidable is when the agreement is actionable, but the circumstances surrounding it are questionable by nature. For example, undue pressure from others, or the person which signed the contract was under an intoxication state. And thirdly, enforceable contract. An enforceable contract. It is this one is it is a valid contract, but either party may refuse to complete it to complete their obligation under the contract, and they cannot be compelled not not for fulfilling their obligation. If the contract, but either party may refuse to complete their obligation of the contract, and they cannot be compelled. Just 1 minute. A valid contract, but either party may refuse to complete their obligation under the contract, and they cannot be completed, cannot be compelled for fulfilling their part, for fulfilling their obligation under the contract. Okay. So a valid contract, it is first of all a valid contract and enforceable contract. Okay, but either party may refuse to complete their obligation under the contract, but they cannot be compelled for fulfilling the obligation under the contract. This is because because of a misrepresentation or lack of evidence of the terms under the contract. Okay, just I try to summarize it here. So an example of avoidable contract. For example, an avoidable contract is when the parties has entered into the contract, yes, but however there is a lack of some information which is missing. The terms and conditions are not well specified. All right, and this makes it void. How it may be void? The parties, as there are some information that was missing under the contract or misrepresentation. Because either party or the contract may choose, okay, not to to move on under the contract. And if one party does not move under the contract, it becomes void. Is it clear? Again, I explained to you, avoidable contract is when a party may set aside. See here, a party has the option to set it aside. Which is what do I mean by set it aside here? They decided to move on with the contract. And why they had the option to do this? Because some terms and conditions of the contract are not mentioned, or the contract is itself illegal. All right? Do you have any further question? Okay, that's good. An enforceable contract, an enforceable contract, if it is a valid contract, okay? It is legally bind, it is legal, and all conditions under it is correct. But however, a party might refuse to complete the obligation that has been agreed beforehand, and they cannot be compelled to do so because the final signed contract, there was some misrepresentation or lack of evidence of the terms. All right, so this is an enforceable contract. And now, let's move on general issues surrounding contract. General issues, which means even if there is a law, a contractual law, all right, but however, there are some situations whereby some situations which makes like the contract to be, even if it is legally bound, but it has some issues which makes the contract it can be even it is a contract which is legally correct, but however these issues which are generally, like for example bargaining power of someone, okay, these are issues which surround the contract when entering in the agreement between two parties. So general issues surrounding a contract. Again, as I say, general issues is like, for example, some problems that are occurring when a party is entering the contract with another parties. Even if there is a law, these issues still exist. Okay, inequality of bargaining power. You will agree with me that when we enter a contract, the bargaining power of the parties involved in the contract are not the same. Okay, they don't have equal bargaining power. For example, if someone is going to an interview, okay, they are going to discuss on the salary. The bargaining power of the parties, the interviewer and the interviewee are not same. The interviewer has a greater bargaining power here. When the parties contract, means that they enters the contract. When two parties contract, naturally they don't have equal bargaining power. Yes, this is something which already exists. Okay, some has superior power and the other has inferior power. Okay. The law generally intervenes when the former takes unfair advantage of their position. When, for example, someone with higher power, when deciding the contract, and they takes unfair advantage of their position, since they have the higher power of the higher bargaining power, they take some unfair advantage of the person who has some lower power. Generally, the court intervenes in the situation. Okay, and not simply because one party was in the inferior bargaining power. This is not generally because someone has the inferior power. Okay, it is always the case when entering an agreement. One will have there is no equal bargaining power, but one will have a higher bargaining power and one will have a lower bargaining power. But the court intervenes when there is an unfair advantage of the person who has the higher bargaining power. Okay, when unfair advantages they take of their position. Okay, they take some unfair advantage. This is where the court will intervene. Again, I say they don't intervene because there is an inequality in the bargaining power. Okay, they don't intervene because there exists inequality in the bargaining power, but they do intervene when there are unfair advantages from of one party to the other. Freedom of contract. The principle that parties are completely unrestricted in deciding whether or not to enter into an agreement. If they do so upon what terms is called freedom of contract. Okay? So, freedom of contract, the parties are unrestricted in deciding whether or not to enter an agreement. They cannot be forced to enter in an agreement. And if they do so, under what terms? All right, they need to agree on the terms and conditions when entering the contract. So this is what is called freedom of contract. However, recent laws have put some restriction on the freedom of contract. It is clear that one party is taking unfair advantage of the weak position of the other. Okay, so the court has set up some laws, right? When because it is clear that in most of the cases that someone with inferior position, someone with higher position is taking unfair advantage of someone with a inferior position. Laws like Unfair Contract Terms 1977 and Consumer Rights Protection Act 2015 are made for this. Okay, these are laws that has been enacted to prevent some unfair advantages taken by those who has power under those who have lower power. Okay. The standard form of contract. Again, standard form contract, these are documents prepared by larger organizations. It is of generic nature. The standard form of contract is a document prepared by many large organizations setting out the terms on which they contract with their customers. Okay. The individual usually take it or leave it. There is no here negotiation because these are sent to the general public. Such contract, standard form of contract, this sent to the public. Okay, they just fill the form and sign on it. The individual has just to take it or leave it. There is no negotiations here. Okay, the terms of a contract here is generic. Mass production and consumerism have led to a standard form of contract. They are used, for example, a contract has to accept the supply of electricity on the electricity company terms. Okay, right? For example, in England, there are many companies supplying electricity, but they have to accept on the company's terms. There is no negotiations between the parties. You either take it or leave it. If two companies are dealing, then reality must be studied to assess whose terms were agreed. If it's unclear, then non-standard terms will be considered applied. Instead, sale of goods, ACCA rules will be considered. Okay, so this is standard form of contract. Battle of form. Disputes sometimes arise in commercial agreement because each party is accustomed to doing business on its own standard terms and argues that they apply to the contract rather than to other parties' terms. Again, this battle of form against the standard form, it is this part of the chapter leads to the standard form of contract against these standard form, generic terms and conditions when entering into the business between the parties. But however, there may be some disputes which may arise because the client might wish to do business under its own terms. All right? The supplier is supplying the terms and conditions, which is generic to its customers, but the customers might want it under its own standard terms. So arguments, disputes can arise on this. But again, standard form of contract, you either take it or leave it. Okay. Again, this is due because each party is accustomed to doing business in its own standard terms. Okay. An example, where supplier tells the customer that the payment has to be made under the terms and contract, instead of terms of contract, that payment has to be made within 1 month. All right. But the customer itself, it has some, for example, some cash flow planning. It said, no, I can't pay in 1 month time. I pay in, like for example, in 1.5 month time. So this is where the battle of forms occur. But for the supplier, it is general. It is its policy that the client has to follow. But the client itself, he has some strategy, some cash flow planning. So he can't like agree on this term. So this is how disputes arises because each party is accustomed to doing business in its own standard terms. The battle of form occurs during negotiation, where each party submits their own terms as part of the draft contract. Okay, so here it is usually occurred in the negotiation phase, where the suppliers say, I have a standard form of contract, you either take it or leave it. But however, the client negotiate here, enter into negotiation to change some parts of their standard form of contract to make it much more into their own standard terms. And this is where the disputes arises. Okay, so just to summarize here, issues surrounding a contract. You have any question on this? Okay, that's good. Thank you, Yajna. And my target, Yajna, is to make you have good results on this because I see that you are a very attentive student and I see that you have been listening to till now and doing all the homework and practice and you've been revising very early. You have a very good potential to obtain good result on this paper and I want you to get it. So we are going to just listen to my advice and each and every week practice the question. The practice against makes you perfect. And I must say that you are on the right direction. Just keep on doing it and our target will be achieved. Okay. Inequality, for example, general issues surrounding contracts surrounding. For example, here one is inequality of bargaining power, inferior parties with higher bargaining power. Bargaining power is, for example, just in the negotiations, so right? Someone has some higher power when negotiating, someone has a lower power because of their position. But party with higher bargaining power, due to their position, takes unfair advantage with someone with lower bargaining capacity. Bargaining someone with higher bargaining power takes unfair advantage. Example, this is an example, right? The law intervenes when there has been an abuse of the bargaining power. Power of someone, all right? Someone with higher bargaining power. Of higher position. And we have, for example, just 1 minute. Okay. So freedom of contract is second. The freedom of contract is the principle whereby parties are completely unrestricted in deciding whether or not to enter into an agreement. And if they do so, under which terms and conditions. Recent laws such as unfair contract term 1977 and consumer rights act has been developed to restrain a party from taking unfair advantages to another. Okay, so this is freedom of contract. Third, the standard form of contract. This is generally a document prepared by large organizations setting out the terms and conditions and under their customs. Okay, the individual either accept or rejects it. Example, for example, here, customer accept their customer accept their supply of electricity under the company's terms. They are here. The customers are unlikely to be able. I just add something here just for you to understand. The customers are unlikely able to negotiate the terms. And sometimes if they represent large organizations, then they can negotiate, unless they are large organization. Okay, not unlikely, they are not able. Okay, so this is standard form of contract, and finally we have battle of form. This is very easy. Simple, each party argues that contract has to be in their own under their own standard and accustomed terms, and this happens during negotiations. Okay, so this is all about the general issues surrounding now form of contract. The contract usually has to be in writing, except in the contract do not usually have to be in writing. Okay, as I said earlier, a contract can be in oral as well, except in the following circumstances. The below circumstances, it has to be in writing. For example, contract by deed. Some contract must be in writing itself, and some contract must be evidence in writing. All right, the following circumstances, which we'll study more in depth in some minutes. Okay. Some contracts must be by deed. Signed and witnessed as formal. Three things. It must be written, it must be signed, and witnessed by some person. A contract by deed is sometimes referred to as a specialty contract. Okay? It is sometimes referred to as a specialty contract. And any other type of contract may be referred to as simple contract. All right? So contract by deed, it must be written, signed, and witnessed as formal. It is also known as specialty contract. And other type of contract are known as to be simple contract. Simple contract are generally written and signed, but here in the deed, the deed has to be witnessed as well. So the contract must be these contracts below must be indeed, for example, leases, okay, a conveyance or transfer legal estate or in the land, including a mortgage, a promise not supported by consideration, such as convenant, for example, a promise to pay a regular sum to a charity. So these are, like, for example, contracts that must be made by deed. The contracts can be made by deed, or some contracts can be made in writing. The following contracts must be made in writing and signed by the parties. There is no witness here. Okay? The contract just need to be written and signed. What makes it different with deed is that deeds has to be witnessed, but these or not need to be, has no requirements to be witnessed. Okay, for example, transfer of share into a limited company, the sale or disposition of interest in land, bills of exchange and check, customer credit contract. These are contracts must be in writing. Okay, and thirdly, there are some contracts, they can be oral, but there has to be evidence in writing. Okay, some contracts may be orally, but they are not enforceable in the court unless there are written evidence of their terms. Because these contracts, you have to have some evidence of their terms, right? So they can't just be oral, it has to be written and signed as well. The most important contract of this type is the contract of guarantee, whereby a guarantor agrees to assume a debtor's liability if the debtor defaults. Okay, these are contract of guarantee. For example, so some companies which settles the debts of debtors, right? There need to be a contract of guarantee. Okay. It has, even if it is oral, there needs to be a signed agreement between the parties, because if tomorrow this is going to be to be debated at the court, you have to have some evidence on this. You need to have the written evidence on these. All right, 3 types of contract which needs to be in writing: the deed, contract which itself has to be in writing, for example, transfer of shares, and the contract that needs to be evidence in writing. Okay, so here, form of contract. Contract do not need to be in writing except for the except in the following circumstances. Example, contract by deed. Need to be in writing, signed, and witnessed. Do not forget that that a deed, it differentiates itself with over right contract which has been written. How? By its witness, because this contract has to be witnessed. It has been signed by both parties. Example, leases contract. Okay, secondly, contract which must be in writing. These are contract which are written and signed by the parties. Okay, here there is no requirement to have witnesses, and if there are witnesses, it becomes a deed. And thirdly, contract which must be evidence in writing. Example, contract of warranty. Okay, these are the form of contract. Now we go to the third part of the chapter, which is offer and acceptance. Again, to have an agreement in place, you need to have an offer and an acceptance. acceptance, as we discussed at the beginning of the course, right? For an agreement to occur, you have a party, which is the offeror, to have to submit to the other party an offer. And if the offeree, the one who has been offered an offer, accept the offer, the terms and conditions of the offer, then the agreement takes place. And if the agreement takes place, both parties are put under the contract, the terms and conditions into the contract. Okay. The first essential element information of a binding contract is agreement. Okay. The agreement is usually evidenced by offer and acceptance. So, for an agreement to occur, one party has to provide an offer and the other party has to accept the offer. Offer. An offer is a definite and unequivocal statement of willingness to be bound to specific terms without further negotiations. This is very important, further negotiations. Okay, so this is a definite, and unequivocal statement. Okay, and a statement of willingness to be bound to enter into contract under specific terms. Okay, when the offer is made, there is no further negotiations. Okay, an offer can be in any form. It can be oral, written, or by conduct. Oral, it has been stated. Written, it has been said through a written statement, or even by conduct. Okay. However, it is not effective until it has been communicated to the offeree. Okay. This is very important. An offer is not effective until it has been communicated to the offeree. For example, a reward offered for a lost item, it cannot be claimed by someone who did not know the reward before they returned the item. Okay, for example, a lost item, there is a reward for it. Okay, it cannot be claimed by someone who did not know that they would have been receiving a reward. Okay, before they returned the item. So this is an offer. Again, an offer is a definite and unequivocal statement of willingness to be bound to specific terms without further negotiations. Okay, so this is an offer. The rules of an offer. An offer can be made to one person or to a class of persons or the whole or the world at large, and only the person or one of the persons to whom it is made may accept it. Okay, an offer must not be vague, it must be clear. Okay, an offer which is being made must be clear, the terms and conditions that it must be clear. However, if an offer can be made certain with reference to previous dealing and customs, then this is not considered vague. Okay, if there is, for example, it is made under some laws, some customs, some previous dealings, okay, it is not considered vague. There has been some previous dealings, some previous offers under the same types of offers previously. And this is in a given case, if, for example, under the same offers, the offeree wants to sue the offerer, but he can't say it is vague because there has been some similar transaction in the past. An offerer is a definite promise to be bound to a specific terms, okay, and must be distinguished from supply of information and invitation to fresh, which we discussed below. Okay, when there is an offer, there is no further negotiations. All right, and a supply of information and an invitation to fret is not an offer, which we will see what is the supply of information and invitation to fret later. Okay, so an offer an offer Let me put it offer, for example. Offer, first of all, indefinite or indefinite and equivocal statement of willingness to be bound on specified terms without further negotiations. When the offer is made, there is no further negotiations. There can be counter offers, which we will be discussing in the later on. But when there are counter offers, the original offer is refused. It is not accepted. A new offer is made. We will be discussing in the later on this. Offer can be written, oral, or by conduct. Okay. However, the offer is not effective until communicated to the offeree. Okay, so this is about offer. Now let's move forward. The following are not offers. We just see here supply information and invitation to threat. Supply of information. Supply information is statement which set possible terms of a contract. Okay. It is not an offer until it is clearly indicated. A supply information is just like, for example, I informing you the terms and condition, the possible terms and condition. The possible, it is here a statement which set out the possible terms of and condition of the contract. It is not an offer unless it is clearly indicated. Okay? This supply information, I'm informing you, for example, I'm willing to enter into contract with you under these conditions. Okay? For example, here it is, the statement itself, which tells the possible for example, a job advert, all right, a job advert which we will not mention everything in it, but it will mention the possible general terms of a job offer. But the offer is not done until it has been negotiated and so on. Then the final offer is made. And it is not an offer unless this is clearly indicated. All right. So a statement of supply information is just a statement of the possible terms of a contract. It is not a contract. It is not an offer. Sorry, it is not an offer unless it is clearly indicated. Again, the offer is when the official offer has been submitted. Supply statement of intention. This is supply information now. Statement of intention. Advertising that an event such as auction will take place is not an offer to sell. Okay, this is an example of statement of intention. Advertisement. All right. Potential buyers may not sue the auctioneers if the auction does not take place. This is an example of statement of intention that is not actionable. Okay, this is statement of intention. All right. Invitation to threat. This is the most important part here. What is invitation to threat? Invitation to threat is not an offer, but it is inviting the other party to make an offer. All right. Here, it is not an offer. The person which is, for example, advertising something, it is not making an offer. The person which is, for example, because why is advertising not an offer? Because there can be some further negotiations when the other party purchase. When the other party say, okay, there is some shoes which is being sold for 1,000 rupees, Mauritian rupees, okay? This is on the shelf, all right? This is advertised on the shelf. and the other, once someone see the shoes, he wants to buy it. He say, okay, he negotiate. He say, I will not buy it for 1,000, but 500. This is the offer. The display, the advertisement is not the offer, but the person who is going to negotiate like for example to buy something and reduce price. This is the actual offer. So invitation to threat here, it is not an offer, it is actually inviting the other party to make the offer. Okay. An invitation to threat means inviting the other party to make an offer. Here it is. It is an invitation to make the other party to make the offer. It is not the offer, but it is inviting the other party itself to make the offer. In other words, it is an indication that a person is prepared to receive offers. Yeah, it is an indication that the other party, that the party is prepared to receive offers with a view to entering a binding contract. Right? Of course, if it is receiving offers, it will, of course, go into a binding contract. So this is invitation to threat. Okay, invitation to threat is not an offer. All right, this is very important. Invitation to threat is not an offer. It is actually inviting someone else to make the offer. For example, auction sales. Auction sales, for example, you want to bid, okay, to bid to purchase something. All right, when you bid, the auction sales, the auctioneer will, for example, is free to accept or reject offers. Okay, but the bid of the public here is the actual offer. All right, in an auction sales, for example, some people might be willing to buy something. It is offered to the public to bid prices on this. The bidding which is being made by the public is the offer. Not what is being displayed to be sold, but the price which is bidding by the public. This is the offer. So it is an invitation. The auction sale is an invitation to sales. Why? Because it is making the public to bid on something, to buy something. And the bidding which is being made, this is the offer. Okay, so advertisement, as I just said, for example, you get shoes which is, for example, displayed on shelf for 1,000 rupees. And you, like, for example, you make an offer to buy it for 500. This is the offer, not what is the price which is shown onto the shelf. Exhibition of goods, for example, again, this is public displaying of goods in a shop window. All right, invitation to tenders. Tenders is where some people are invited to provide their best price, their terms and conditions to enter into a contract. This is an invitation to threat because the public is again here to send their bid, the tenders. All right, the tenders is from the public or the offers. All right, then the invitation for tenders. The invitation for tenders is not the offer, but the real tenders, which is being provided, which is being set by the public, by anyone from the public. This is the actual offer, and the one who is inviting people to tender has the right to accept or reject any of the tenders. Okay, so auction sales. At an auction sales, the bid price, the person's bid is offer. Again, as I said earlier, the public here in the auction sales, they are going to bid a price to buy something. The bid from the public, from the person in the public, from anyone on the public is the offer. The auctioneer is free to accept or reject it. The auctioneer is inviting the people to bid. So it is an invitation to threat. All right. The person's bid, anyone and the public who is bidding to purchase something, this is the actual offer. An auction is an invitation to threat, whereby the offers made by bidders stating the price which they are prepared to buy. Okay, this is the offer, and again, the offers are the bidders. All right, the people, the public which are offering to buy these how much they are willing to buy a product. So this is the offer. All right, and acceptance takes place only when the acceptance takes place at the fall of the auctioneer's hammer. All right, this is acceptance when the auctioneers agree to sell to accept the highest bid price. Usually, it is the highest bid price. Accept it. It falls under the auctioneer hammer. Then you know that acceptance has taken place and the contract has been agreed. Where an auction is stated to be without reserve, the auctioneer is offering goods for sale. The bid is the acceptance, all right? And which the auctioneer is free to accept or reject. A reverse is a specified minimum price. Okay? Advertisement. An advertisement of goods is usually an attempt to induce offers, and therefore an invitation for threats. The circulation of a price list is also an invitation to threats. For example, you get a brochure by email telling you the prices of laptops, the promotions, and so on. And these are like invitation to threats. Actual offer occurs when you send your consentment to purchase, and if the person agreed to sell it with you, then this is acceptance. Okay, this is a case. Again, these cases, or like you don't need to learn these cases to memorize these cases. Okay, you just have to read it and understand it in order to understand the logic behind these the chapters. So in Partridge vs. Crittenden, 1968, Mr. Partridge placed an advertisement for Bumble Fitch hens, 25 each. The Royal Society of Prevention of Cruelty of Animals brought a prosecution against him for offering to sell brambling hens in contravention of the Protection of Birds Act. The justice convicted Partridge and he appealed. Okay, they convicted Patrick, but Partridge appealed. The conviction was quashed. Okay, so the conviction was rejected. Although there has been a sale in contravention of the act, but the prosecution could not rely on the offense of offering for sale. Because the advertisement was just not an offer to sale, but what was it? An invitation to threat. Okay, it was not. It did not sell the hens, but it was like, for example, publish an advertisement to sell these hens, these cocks for 25 cents each. But however, it was not an offense because it was an invitation to threat and not an offer for sale. Exhibition for sale of goods. Exhibition of goods for sale. Displaying goods in a shop window or to open shelves of a self-service shop, or advertising displays of goods or invitation to threats. Yes, because any goods that is displayed on shelf or advertising of goods, again, the person which is going to buy, this is the offer. And it is going to buy, and if it is accepted for the purchase by the seller accept for the who is willing to buy, accept the price which has been, for example, in a situation whereby the buyer offers to buy it for a reduced price and the seller agrees to it. The offer that has been made by the buyer to buy it at a reduced price is actually the offer, and the acceptance occurs if the seller agrees to sell it at this reduced price. This is why exhibition of goods, it is not, for example, an offer, because it can be further bargained. Okay. displaying goods on shelf windows, advertising, or displays or invitation to threats. This is because they are not binding as such. For example, a price displayed next to a product does not constitute an offer as they can be bargained. This is what I just explained. The prices that has been displayed, the goods has been displayed, this can further be bargained. Okay. In Fisher vs. Bell 1961 case, a shopkeeper was prosecuted for offering the sale of offensive weapon by exhibiting a flick knife in a shop window. The Restriction of Offensive Weapons Act 1959 creates a criminal offense for offering for sale certain offensive weapons. So this is a restriction of the Restriction of Offensive Weapons Act. The shopkeeper was prosecuted under this statute for displaying flick knife in his shop window. Held, the shop window was not an offer to sale. It was not an offer to sale, but what it was? An invitation, only an invitation to threat. So the display did not infringe the law. The law tells you you can't offer for sale. All right? But he just displayed it. It was not an actual offer. It was what? An invitation to threat. So he did not, the display did not infringe the law. Okay. Thirdly, invitation to tenders. All right. Invitation to tenders. A tender is an offer to supply specified goods or services at a stated cost or rate submitted in response to prior invitation for tenders by the purchaser. All right. The prior invitation to the purchaser is what? An invitation to threat. The tender is the offer. Okay. So the tender is an offer in response to prior invitation for tenders by the purchaser. Again, the tender is an offer, but the invitation to tenders is not the offer. It is the invitation to threats. Again, invitation to threats is to invite someone to make an offer. When a supplier tenders for a contract that they're making an offer to the purchaser who has advertised a contract as being available. The effect of invitation to tender depends on the wording used. This is very important. It depends on the wording used. There are two types. They can be of two types. If the invitation states that the purchaser will require the successful supplier to supply them, usually of a large one-off supply, then acceptance of the tender constitutes to a binding contract. If there is a one-off supply, then the acceptance of the tender constitutes to what? The binding contract. However, there are sometimes that there are different supply which is being made, but each supplies are individual contracts. We will discuss in later on. But here, what you need to understand is that if it is a one-off supply, okay, the one-off supply, it is a binding contract. Tenders, which are usually one-off supply, it is a binding contract. If the invitation states that the purchaser may require the successful supplier to supply him, then acceptance of the supplier creates a standing offer. Okay? Standing offers means that under the tender, the purchaser does not have to buy any goods from the supplier but may not purchase from another supplier. Right? This is our standing offers. So, an standing offer, under the tender, the purchaser does not have to buy any goods from the supplier, but may not purchase from another supplier, right? So these are standing offers. However, any purchase orders that the purchaser will make, these are separate contracts, if of course there is acceptance from the other parties. So this is one-off supply here. Here there will be different supply. So each supply individually constitutes to a single agreement, each of them. Unless there is a binding objection to keep it open for a certain period of time, Okay, this is again for the purchase orders. The purchase orders, the supplier makes separate acceptance, and the separate acceptance make the separate contracts, and delivery must be the delivery must be made within the time stated in the sending offer. Okay, so the separate acceptance of separate offers or separate contracts under the tenders, unless there is a bidding obligation to keep it open for a certain period of time, the supplier may revoke its standing offer at any time. If, for example, there is no binding obligations to keep it open for a certain period of time, the supplier may revoke its standing offer at the time, but needs to fulfill orders placed to create contractual obligation, but prior contractual obligation that has been agreed must be filled. Alright, so this is invitation to fret. So the following are not offers. For example, one, supplier of information. Some information, it is only statement which set possible terms of a contract. Not a contract, not an offer, sorry, unless what clearly stated. Secondly, statement of intention. Example, advertising that an event such as an auction will take place is not an offer to sell. Okay, so there's an advertisement, for example, an event such as an auction will take place is not an offer at all. All right. This is because the potential buyers may not sue the auctioneer if the auction does not take place. Okay. And thirdly, invitation to threats. This is actually intention for the other party, intention to make the other party entering to make the offer party making an offer. To make to all right. Example, for example, we have auction sales, advertisement, or advertisement exhibition of goods for sale, and invitation for tenders. Auction sales. just some brief introduction, some brief explanation on these I will make just to facilitate your understanding on these. At an auction sales, the person bid is the offer, whereby the auctioneer is free to accept or reject. Advertisement. An attempt to induce offers. And another thing as well is circulation of price list is also an invitation to fraud. And exhibition of goods for sale, for example, displaying of goods. In a goods shop window, because is or invitation to fret, because the prices can be further negotiated. All right. Invitation to tenders. And don't forget, when there is an offer, there is no further negotiations. An invitation to tenders, a tender is an offer to supply specified goods or services at a stated cost or rate submitted in response to a prior invitation for tenders, and is therefore an invitation to fret. Okay. All right, and now we are going to study the termination of offer. What terminates an offer? All right. In the absence of acceptance, an offer may be terminated in the following ways. Just 1 minute. Okay. In the absence of an acceptance, an offer may be terminated in any of the following ways: rejection, counter offer, lapse of time, revocation, failure of a condition, and death. These are cases which, for example, may terminate an offer. Rejection is, of course, rejecting the offers, and it automatically terminates the offer. All right. So rejection, this is simple. You just want to the rejection by the offeree automatically terminates the offer. It is actually refusal to accept a contractual offer. All right. So this is very simple. Just rejecting the offer, it automatically terminates the offer. Counter offers Counter offers is like you have been given an offer, but you want, as a result, you are not too much satisfied with the offer, with the conditions. You want to make another offer. The counter offer occurs such that the original offer is made, is rejected, and a new offer is made in response to the rejection. All right. Counter offer is made in response to an offer. Okay. A purported acceptance to which induces new terms is a counter offer, which has the effect of terminating the original offer. This is very important. It terminates the original offer, and a new offer is submitted in the response by the counterparty. Okay? A counter offer may, of course, be accepted by the original offerer. Of course, this even if there is a counter offer, this can be accepted, all right, and it can be rejected as well. Again, a counter offer is an offer which is made in response to another offer. It involves that the original offer is terminated and a new offer is made by the offeree here, which becomes now the offerer, to the original offerer. All right, a new offer is made in response to the original offer by the offeree. All right, and it constitutes terminating the original offer. A new offer is made in response, and of course, the original offerer, the one who made the offer before, has the right to accept or reject it. This is normal. But here, what is important is that when there is a counter offer, the original offer is terminated and a new one is made in response to the original offer. Hyde and Rech, 1840. The facts were that Rech offered to sell Hyde a form for 1,000 GBP. Hyde made a counter offer by offering it to purchase it for 90.50. Rech rejected it. Later, Hyde came back and said that he now accepted the original offer, but even Ref rejected it. Again, what happened here is Rech offered to sell a form to Hyde for 1,000 pounds sterling. Hyde made an offer, a counter offer, say, okay, he's not going to purchase it for 1,000, but he's going to purchase it for how much? 950 pounds sterling. Rech rejected this counter offer, but later what happened? Hyde came back and said he now accepted the original offer. But again, Rech even rejected the original offer as well. Hyde could no longer accept the original offer. It had been terminated by the counter offer and was no longer capable of acceptance. His acceptance was merely a fresh offer, which Rech was free to turn down. So this is the ruling here. Okay. Here what happened? As Hyde rejected the original offer, he did not reject the original offer, he made a counter offer, but when he made the counter offer, this means that the original offer has already been rejected and it was already over. Okay? And even if he accepted the original offer, Rech was, like for example, was in a position to be able to accept or reject it. Again, what happened here? The counter offer terminated the original offer. And the original offer and the counter offer, of course, the Rech was in a position to accept or reject it. He rejected it, and now Hyde, who wanted to go under the original contract, and this Rech was in a position to accept or reject it because the original contract was already terminated when there has been a counter offer. Exception, request for information. One thing you have to be noted is that request for information is not counter offers and is not a rejection. Okay? Exception. Request for information is not rejection. You just want to be like, for example, as discussed earlier, when entering into the contract, both parties must be clear on what has been decided between them. They must be clear in the terms and condition before, like for example, going on with the contract. The request for information, additional information, is not a rejection of the contract, but it is neither a, like for example, a counter offer, but it's just a request for information, for additional information to ensure that he has sufficient information to move forward to accept or not the contract. It is possible to respond to an offer by making a request for information. Okay, such request may be a request as to whether or not the terms will be acceptable. It is not a counter offer. This is very important. A request for information is not a counter offer. I'm requesting you something doesn't mean that I rejected the original offer or has made a new offer in response to it. So request for information is just requesting to have better information, better ideas on the contract, on the agreement, and the terms and conditions. So this is not a rejection, neither it is a counteroffer. This is the case, for example, for between Stevenson and McLean in 1880. The facts M offered, M is McLean, offered in writing to sell a quantity of iron to S. S is Stevenson at a given price. S replied querying delivery times. What happened? He responded requesting the delivery times. But before receiving a reply, sent a further letter accepting the offer. It even sent a letter for accepting the offer. So S requested the delivery time and also sent a letter for that he is accepting with the offer. This acceptance crossed in the post, and the letter was a letter of revocation from M to S. Okay. When he requested for additional information, M, which is McLean, they sent a letter of revocation. What is a letter of revocation? We will study this later on, that they have revocated the offer. They are not going to move on with the offer. M refused to supply the iron with S, arguing that S query was a counter offer. He said that the request for information was a counter offer. What held at the court, M could not treat the query as a counteroffer because, again, request for information is not a counteroffer. S had not intended to prejudice M's position, but he wanted just to establish the parameters of the deal. Okay, so here what happened is that M just wanted to have some further information on the deal, just to be sure of the parameters of the deal. He requested for information. The request for information is not a counteroffer, and therefore it does not, for example, terminate the original offer. So the offer was still open, and the offer was still open, and when S wrote of accepting it. So when McLean offer was still open when Stevenson accepted it, and therefore the offer had to move on. All right, because there has been no counter offer, and there has been, like, for example, just that S wanted to understand better the parameters of the deal, so he requested the information. So this was not a counter offer, and it did not terminate the original offer. So the letter of revocation from McLean to Stevenson was quashed. Lapse of time. An offer may be expressed to last for a specified time. If, however, there is no express time limit set, it expires after a reasonable time. Okay? An offer may be expressed to last for a specified time. Yes, it can be expressed to last for a specified time. If, however, there is no express time limit, it expires after a reasonable period of time. All right? An offer can be open for a specified period of time. Yes, let's say for 1 week, 2 weeks, or even 3 weeks, or even a month. All right? But if there is no express time limit of the period, of course, it has to be expired. We can't, like, for example, send an offer today and wait for 2 years for the offer to come back. So it expires after a period of time, a reasonable period of time, a reasonable period of time. Okay. In Ramsgate vs Victoria Hotel, in Ramsgate Victoria Hotels Company vs Montefiore 1866 case, the defendant applied to the company in June for shares and paid in deposit. Okay. At the end of November, the company sent him an acceptance by issuance, a letter of allotment, and requested the payment to be made for the balance due. The defendant contended that his offer was expired, could not be accepted. When the offer was made in June, okay, he applied for to invest in the company in June and even paid a deposit for it. But at end of November, the company sent him acceptance of letter. June, you have June to November. June, like for example, 5 months, okay? 5 months, after 5 months that the company responded, okay, their acceptance, his issuance of allotment and requested payment of the balance due. After 5 months, okay? What held actually the decision of the court? The offer was valid for a reasonable period of time only, and 5 months was too long. Okay? 5 months was too long here. What happened? Again, I'll explain it. The defendant offered in June to buy some shares and even pay the deposit, but it is in November that the company sent him the letter of allotment and requested to pay for the balance due. But the defendant at that time said that his offer was expired and could not be accepted. And he was right, because the offer is valid only for a period of time. And 5 months, starting from June to November, was too long. Revocation. Revocation, the offerer may revoke their offer at any time before acceptance, even if they have said that their offer shall remain open for a specified period of time. Okay? The offerer may revoke their offer at any time before acceptance, even if they say that their offer shall remain open for a specified period of time. However, if they have kept a separate contract in which they have formally agreed to keep their offer open, known as option contract, then they may not revoke the contract during that period. Revocation may be express statement only, or by act of the offerer. Where revocation is an express statement, it does not take effect until the revocation has been received by the offeree. Alright, so an offer can be revoked at any time before acceptance. Okay, and if they say that they is open for a specified period of time, even in this specified period of time, they can revoke the offer. However, if they have a separate contract which they have formally agreed to keep the offer open, like for example, and this is known as an option contract, then during that time they cannot revoke until the option contract is terminated. For example, the time specified in the option contract is completed. Revocation may be an express statement form or an act of the offerer. Where revocation is an express statement, it does not take effect until the revocation has been received by the offeree. All right. The revocation letter, what has been that has been sent to the offeree, it does not take effect until it has what? It has been received by the offeree. Failure of a condition. An offer may be conditional, okay, that is dependent to some event occurring, or there is or there being a change of circumstance. If the condition is not satisfied, the offer is not capable of acceptance. Okay. If there is a condition, right, some offer can be conditional, all right. They have to, for example, some condition has to be occurred for the offer to move on. But if in that case this has not been occurred, okay, the condition has not been occurred, then the condition is not satisfied, for example, then the offer is not capable of acceptance. For example, in the financing limited and Stimson case 1962, the defendant wished to purchase a car. On 16 March, he signed a hire purchase form to purchase the car. The form issued by the claimant stated that the agreement would be binding only upon signature by them. Okay. So the agreement stipulated that it will only be binding when it is signed by both of them. On 20 March, the defendant was not satisfied by the car and returned it. Okay. He returned the car on 20 March, and on 24 March, the car was stolen from the premises of the dealer and was recovered badly damaged. There are different situations that has occurred here. First of all, 16th of March, the defendant signed the hire purchase agreement. Okay, and 20 March, the defendant returned the car because it was not satisfied by it. And 24 March, the car was stolen and was badly damaged. And 25th of March, the claimant signed the form. Okay, this is on the 25th of March that the claimant signed the form. They sued the defendant for breaching the contract. All right, they say that the defendant broke the contract for returning the car. Decision: the defendant was not bound to take the car. Okay, his signing of the agreement was actually an offer to contract with the claimant. There was an implied condition in this offer that the car would be in a reasonable state. However, it wasn't the case. Okay, so the implied condition into this case was that the car should be into a reasonable condition, which was not the case. So the defendant was right about it. He won his case. Again, what happened is that there was, when he was purchasing a car, what he expects to it is that the car was in a reasonable condition, but it was not the case. Okay, termination by death. The death of an offeree terminates the offer. Listen, this is very important. The death of the offeree terminates the offer, but the offerer's death also terminates the offer unless the offeree accepts the offer in ignorance of his death, and the offer is not of a personal nature. The death of the offeree terminates the offer. The offeree, the one who is being offered the offer, his death automatically terminates the offer. There is nothing. There is no condition at all. But however, the offerer's death, it also terminates the offer. But however, if the offeree accepts it, given that it is not in its personal nature, okay, the offer goes on. But however, he is, for example, not in personal nature, and he was in ignorance of the death of the offerer. All right. Again, I'm explaining it. The death of an offeree terminates the offer. The offerer's death also terminates the offer unless the offeree accepts it in ignorance of the death of the offerer. And the offer is not of a personal nature, then it is accepted. Then it is the contract is made. The agreement is valid. Okay, so this is about termination of offer. Okay. So termination of offer, again, just to summarize, termination of offer. First of all, rejection. Rejection, it is simply refusal of the offer. Secondly, counter offers involves rejecting the original offer, and another offer made by the offeree okay. So this involves rejecting the original offer and the offer made by by the offeree as a result. Okay. The original offer, of course, the original offer, the original offer is terminated and a new offer is proposed. By the offeree. Okay. Request of information is not a counter offer and does not terminate an original offer. Lapse of time. An offer expires after a reasonable period of time if there is no response from the offeree. Revocation. Revocation can be made at any time before acceptance. But the revocation does not take effect until communicated to the offeree. Okay. And a failure of a condition of these are some offers may be conditional and it depends on some condition or being any change in a circumstance make the offer not capable of acceptance. The implied condition make the offer not capable of acceptance. Okay, termination by death. Death of offerer automatically terminates the contract. However, death of offeree which terminates the contract death of offerer also terminates the contract, terminates the offer, but however, if it is accepted by the offeree ignoring the death of the offerer and the offer is not of a personal nature, the contract stands. The agreement is valid. Okay. All right. Now let's move to the next part of the syllabus, which is acceptance. Okay, acceptance is simply unqualified and conditional agreement to all terms which brings the parties into effect. Here, the offer has been made, it has now been accepted, and the acceptance itself makes the parties bind under the contract. And here, when there is an acceptance, there is an agreement. The agreement is valid, and now it brings the parties into a contract, right? With the contract into effect. Okay, so this is acceptance. Upon acceptance, the contract comes into effect. Okay, so when there is acceptance, there's an agreement, and there's an agreement. When there is an agreement, there is a contract. Again, let me tell it again. When there is an acceptance, there is an agreement, and when there is an agreement, there is a contract. And so the contract comes into effect when there has been an agreement, when has been an acceptance of an offer. So this is a point of no return. Okay, when there is an acceptance, this is a point of no return, and the parties are legally bound to the contract. Okay, we're bound to the terms that they have agreed. Right. So when there is an acceptance, the agreement is now valid, and there is now a contract between the parties. The parties are bound to the terms and conditions that governs the contract. Factors affecting acceptance. There are some factors which affects acceptance. For example, silence. Silence does not mean acceptance. All right. Okay. If there is a silence from the offeree, this does not mean that the offer has been accepted. Okay. For example, here in this in Fethouse with Bindley 1862 case, the claimant wrote to his nephew offering to buy the nephew's horse, adding, "If I hear no more about him, I consider the horse mine." The nephew intended to accept the uncle's offer but did not reply. What happened? He did not reply. He instructed the defendant, an auctioneer. The defendant was actually an auctioneer, which sold the horse under an auction. Owing to a misunderstanding, the horse was sold to someone else. The uncle sued the auctioneer. Okay, the action actually failed because the claimant had no title to the horse. Okay, the claimant, which is the uncle, he had no title to the horse. The horse was not his. This is the first point. And secondly, The nephew never accepted the original offer because he did not reply. Silence means no acceptance. Right? So this is the case, the decision of the case. The action failed, and the claimant, since the claimant had no title to the horse, and also there was no acceptance from the nephew because he did not reply. Acceptance subject to contract. This is type of acceptance whereby there need to be a written contract to it, okay, to, like, for example, support on what has been agreed. Acceptance subject to contract means that the offeree is agreeable to the terms of the offer, but proposed to the parties should negotiate a formal contract. Okay, so acceptance is, for example, here, subject to contract is acceptance of the offer, yes, but however propose that there need to be a formal contract, but that needs to be signed. Neither party is bound until the formal contract is signed, all right? Even though they are in an agreement when there has been an offer and an acceptance, but the parties are not bound until the formal contract is signed, okay? Agreement for sale of land in England is usually subject to contract. Of course, this needs to be evidenced in writing. Acceptance subject to contract must be distinguished from outright acceptance made on understanding that each parties wish to replace the primary contract with another at a certain stage. Right? Even if the immediate contract is described as provisional, it takes effect only once. Again, as I said, the original contract, even if not written, they has been already discussed and agreed. It takes effect once they has agreed on same. All right? But parties are not bound to it, not bound until a formal contract is signed. So this is acceptance subject to contract. Letter of intent. Letter of intent or indication from one party to another that they may place a contract with them. Usually, a letter of intent is worded so as to create a legal obligation. However, in some cases, it may be phrased so that it includes an invitation to commence a preliminary work. In such circumstances, it creates an obligation to pay for the work. All right? And finally, furthermore, it's acceptance of a tender. A tender, again, is an invitation to fret, as we discussed earlier. A tender can be one task or supply or series of tasks. Each task is a separate contract. A tender to perform one task, such as building a new hospital, is an offer which can be accepted. All right, the tender from the public, this is the offers from the public, and the best tender, the person, the purchaser, who is inviting people to tender, he will look at the terms and conditions, the prices, and he will accept it. And this is where the contract is now valid. A tender to supply or perform a series of things. To supply or perform a series of things, as we discussed earlier. All right. So each series of things under the contract is individual agreement, individual contract. Example: supply of vegetable in a restaurant daily is not accepted until order is placed. All right. The acceptance depends on the order. This is what is called standing order. All right. So each order placed is an individual offer, and the acceptance of the acceptance of the order create a contract. So each supply is a individual offer which constitute an acceptance, each of these, and when they are accepted, then they create a contract. Until orders are placed, there is no contract, and the tender can terminate the standing offer. All right, until there is no order. Okay, there is no order, there is no contract, and the tenderer can terminate the standing offer. Cross offers or requests for information. Cross offers do not constitute to acceptance. They are making a new offer which may in turn be accepted or rejected. A request for further information is not an acceptance. All right. So, acceptance and unqualified and unconditional agreement to the terms of an offer and therefore brings the contract into effect. This is a point of no return and the parties are legally bind to the contract. Right? So when there is acceptance, the contracts come into effect. Okay? The factors that affect acceptance. So of all, for example, silence. Silence is not acceptance. Acceptance subject to contract. This means that the offeree is agreeable to the terms and to the terms of the offer, but proposes that the parties should negotiate a formal contract. Okay? The parties are not bound to the contract until it is signed. However, even if the original, let's put it as provisional contract is provisional, that is the final contract is what has been signed, it takes effect only once, but they are bound to it when it is signed. Letters of intent. Letters of intent are an indication by one party to another that they may enter into a contract with them. Usually, all right. And finally, finally, one second. Acceptance of a tender. Tenders are generally invitation to threats, right? And tenders can be of two types. such as one task, example, building a hospital, several tasks. It can be of supply of things. Example, supply of vegetables, to a restaurant daily. The restaurant daily. No acceptance occurred until a fresh order is placed. So each order constitutes to a separate contract. Okay. Now communication of acceptance. Okay. Communication of acceptance, there is a general rule on how acceptance, if the offer should be communicated. However, there is a number of exceptions. General rule of communication. The general rule is that acceptance must be communicated to the offerer. That is not effective until this has been done. All right. The general rule of communication is that the offer is not effective. The contract is not effective until it has been communicated. The communication has been received by the offerer. The offerer, yeah. All right, again, the general rule is that the acceptance must be communicated to the offerer, and this is not effective until this has been received by the offerer. Exception to general rule of communication, waiver of communication. Okay. The offerer may dispense with the need to communicate of acceptance. As such, a waiver may express or may be inferred from the circumstances. For example, in unilateral contract. A unilateral contract is where the offerer agrees to do something once another party who they might not know performs an act. They also occur if a party in ignorance of offer performs an act which fulfills the terms of the offer. An ordinary offer can be revoked at a time before acceptance, and once revoked can no longer be accepted. However, in some cases of a unilateral contract, the court have held that an offer cannot be revoked once the offeree has begun to perform whatever is necessary. No prescribed mode of communication. Where there is no prescribed mode of communication, the offeree can use a method which is effective but needs to ensure that this is communicated to the offerer. Where no method of communication is stated, the offeree can use any method but must ensure that the acceptance is understood if they choose an instantaneous method of communication. All right. So when there is no prescribed mode of communication, any method can be used as communication, but this must ensure that this has been understood and clear words has been used for the offerer to understand that they have the offeree, which means the offeree has accepted the offer. The prescribed mode of communication, the offerer may call for communication. 1 minute. Okay. The prescribed mode of communication, the offerer may call the communication of acceptance by its specified means. All right. If in the contract it says that there is a prescribed means to communicate an offer, so the offeree must use this specified mode of communication. But however, here you will see communication of acceptance by some other means equally expeditious, generally constitute to valid acceptance unless otherwise stated. All right. Even if they are going, for example, it says the acceptance must be communicated by an official letter by email, by post. But however, the offeree sent email and replied that he has accepted the offer. All right. So this can be a valid acceptance. But however, unless it is specified that the company will only accept letters for the will only consider letters as acceptance. This will probably apply also to acceptance by fax machines or email. All right. However, if the offerer use very precise wording, if a specified means of communication is to be treated as mandatory. All right. So even whatever the source of communication is being used, the specified the wording, the use of precise wording is mandatory. The postal rule. The postal rule states where the use of post is within the contemplation of both parties. All right, must be within the contemplation first of all of both parties. Both parties must have access to the postal to the post. The acceptance is complete and effective as soon as the letter is posted. As soon the letter is posted, not received but posted, here it is the acceptance is complete and effective. Even though it may be delayed or even lost altogether by the post. Okay. So the postal rule states that the first rule is that the post must be in the contemplation of both parties, the offerer and the offeree. And acceptance is complete as soon as the letter has been posted. Even if the letter has been delayed or even lost, but when the acceptance has been posted by means of a letter by post, the acceptance takes place. There are 4 important points to note about the postal rule. The offerer may be unaware that a contract has been made. If this is clearly inconsistent with the nature of the transaction, the letter of acceptance takes place only when received. For example, here the offerer is not aware that the acceptance has been made. Okay. In this because it is inconsistent with the nature of the transaction here, in this situation the letter of acceptance takes effect only when it is received. The intention to use post for communication of acceptance may be deduced from these circumstances. If the offer stipulates a particular mode of communication, the post rule may not apply. Acceptance of an offer may only be made by a person authorized to do so. This will usually be the offeree or their authorized agent or their authorized agent. All right. Here it is or their authorized agent. Cross offers. If two offers in identical terms cross the post, there is no contract. If two offers identical in terms cross the post, there is no contract because the contract stipulates that there needs to be an offer and acceptance. Here there is just 2 offers from each party. There is no acceptance between them. There is no contract. For example, if A offers to sell their car to party B for 1,000 and B offers to buy a car for 1,000, even the terms are similar, there is no contract because there is no acceptance from any parties. Okay, so just to summarize it, communication of offers, the general rule, general rule, acceptance must be communicated to the offerer. Of course, it should be in this reasonable time, and there is no agreement, therefore no contract, until this has been done. So the general rules that acceptance must be communicated to the offerer and there is no agreement until the acceptance has been communicated. All right. And exceptions to general rule. First of all, waiver of communications. In some circumstances, the offerer may dispense with the need for communication of acceptance, which can be expressed or inferred from the circumstances. All right. Here an example, there is like unilateral contract. Acceptance occurs when the offeree performs the required act and does not have to inform the offerer. This is the unilateral contract. Unilateral contract itself this is waiver of communication. Sometimes, for example, in unilateral contract, acceptance occurs when the offeree performs the act. As previously we discussed, offeree can be by oral, written, or by gesture, behavior. All right. So here, he performs the act without communication. So when he performs the act itself means he have accepted the terms and conditions of the contract and they are now bound to enter the contract. Is where the offerer agrees to do something once the other party, who they might not know, performs an act. All right. The acceptance occurs even if the offeree performs the act in ignorance. Example of an unilateral contract. a reward for a contest. In a contest where there are different participants, all right, several participants, the person that has organized the contest, he might not even know the person which has taken the part of the contest. All right, but when they get win the contest, they are rewarded for the contest. So here, what happened is that they never did even do not know the person who has entered the contract, and acceptance has been made by, for example, entering the contest by the offeree. General rule of an agreement is an offer can be revoked at any time before acceptance. Okay? However, in a unilateral contract, there is no the offer cannot be revoked once the offeree has begun to perform whatever act is necessary. What does it mean is that, as we discussed earlier, an acceptance can be by oral, by written, or sometimes it can also be by gesture, by behavior. But here, when the offeree starts doing the work, all right, they has automatically entered into a contract without being informing that they have accepted to enter the contract. No mode of communication prescribed. Where method of communication of acceptance is not stated, the offeree must use a valid way to communicate acceptance, but must ensure to use precise words when communicating their acceptance. So this was precise words to ensure that this has been understood. Okay. Prescribe mode. All right. Prescribe mode of communication. The offerer may call by may call for communication by specified means. Okay. However, even if acceptance is communicated by other means, it equally constitute to a valid acceptance. Example, matching facts instead of email. However, if the valid means of communication if the means of communication is specified in a given circumstances, the offerer must use precise wording to ensure the offeree clearly knows about it. The prescribed mode of communication. Okay. So, and finally, before we wrap up this part, the Postal Rule. The Postal Rule states that where the use of the post is within the contemplation of both parties, the acceptance is complete and effective as soon as the letter has been received. No, the letter has been posted. Okay. Even if it may be delayed or even lost by the post office, but as soon as it is posted, it constitutes a valid acceptance. Crossovers if two offers identical in terms cross the post, there is no contract as there is no acceptance, but only offers. So here it is. Do you have any questions on what we discussed today? Okay, that's good. All right, so this is all for today's session. I will be sending the summarized notes to you shortly, and also next week questions to be prepared, and also the answers to source of law, what we practiced today. And next week okay, we are 8 minutes late because we started at 8, I think at 8:10 we started because there has been some technical issues. So next week we will start our session by practicing question on law of obligation agreements first, and then we will be discussing the next chapter, which is consideration, the law of obligations, considerations. All right. So that is all for today. And anything you have, any question that you might have, please feel free to communicate with me at any time. If even we need to organize some short call, we can do so. And hopefully that you have understand the topic. And again, as I said, if for any question that you might have, please feel free to contact me. So I'm wrapping up this today's session, and I wish you a very good day, a happy Sunday, and hope and see you next week. All right, bye. Bye.